Good evening, everyone. I'm Professor Michelle Foster, the Dean of the Melbourne Law School, and it's my great pleasure to welcome all of you who are here in person, but also who are joining us online to the 2024 Francis Gurry Lecture on Intellectual Property Law. I'd like to begin by acknowledging that we are meeting this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I would like to extend my respect to Elders past, present and emerging. And I extend this acknowledgement to all Aboriginal and Torres Strait Islander people joining us today. Well, this lecture series was established in 2009 by the Institute of Patent and Trademark Attorneys of Australia and Melbourne Law School, and is named in honour of Dr. Francis Gurry, former Director General of the World Intellectual Property Organisation and distinguished alumnus of this law school. This lecture series has enabled and facilitated engagement between the Academy, the profession and the public on key contemporary issues in intellectual property law and policy. We are very grateful to our sponsors who support the series, and I offer an especially warm welcome to colleagues from these sponsoring organisations: IP Australia, AIPPI Australia, the Intellectual Property Society of Australia and New Zealand, and the Licensing Executive Society of Australia and New Zealand. Now, this lecture series is taking place over 2 evenings, and it's my pleasure to open tonight's event before it heads on to Sydney tomorrow. Shortly, I will hand over to my colleague, Professor Andrew Christie, the Melbourne Law School Chair of Intellectual Property, who will introduce our wonderful guest speaker, Dr. Terry Junkie. But first, just some notes about tonight's proceedings. This event is being recorded and will be made available on the Melbourne Law School website. There will be the opportunity for both our in-person guests and also those joining us online to ask questions of our wonderful speaker following the presentation. But with so many of you here both in person and online, we're going to run this a little bit differently. There will be, for those in person, a QR code, which I understand will magically appear as I say the words. Here we go. And so that will enable you to link that and pop your questions into the website. So please feel free to be thinking about your questions as the presentation proceeds and start to submit them. And for those online, there will be a link in the chat for you to do the same. But now it's my great pleasure to hand over to my colleague, Professor Andrew Christie, to introduce formally our esteemed guest speaker. Thank you, Andrew.
Thank you very much, Dean, and I just briefly add my sincere welcome to all of you in the room and online. You give us the most valuable thing you can give us, actually, which is your time, your attention, your engagement. And so do take advantage of that means for engagement that Professor Foster showed you a moment ago. And I will curate your questions in the Q&A time, for which we've allowed a good amount. I find the fact that Indigenous Australians have inhabited the continent for 60,000+ years quite phenomenal, actually. It's very hard for me as a white settler to process that period of time. The way I do it is by saying to myself, that's more than 1,000 years of the life that you've already lived, Andrew. I think for all of us in the room, very much the same thing. If you reflect on that, that is phenomenal. 1,000 times our current lifetimes. Indigenous Australians have inhabited the land, but they haven't just inhabited it, they've been with it, and as a result of that, not just do they have custodianship and unceded ownership, but also have evolved an enormous amount of wisdom and knowledge through connection with the land. That wisdom and knowledge manifests itself in cultural and innovative practices. And as soon as I say those words, we in the room realise that equates to what Western law would consider to be intellectual property. So it's not just appropriate, but it's necessary for the Western legal system to recognise that. And it's very desirable because whilst Australia's blessed with a lot of physical resources, minerals, etc., they'll eventually be depleted or unable to be used due to challenges of climate change. But Indigenous knowledge, culture and wisdom won't ever be depleted, and in fact will become more important because it will assist us to deal with things like the challenge of climate change. So I don't have any doubt that this is a very appropriate, timely topic for us to address tonight in the series. And I have absolutely no doubt that we have the very best person to address us on it. Terry Janke was born in Cairns, and her family has connections not just to Cairns but to the York Peninsula and to the Torres Strait Islands. She's, as you know, an internationally renowned expert on intangible intellectual property, Indigenous cultural property and the like. And you might think somebody who's become so expert must have had a very straightforward path towards that position. But if you read her book, True Tracks, you'll find, not surprisingly perhaps when you think about it, the path slightly tortuous. I won't go through all the twists and turns. I'll just highlight a few for you to contextualise Terry's expertise. She started a law degree at University of New South Wales, but after a couple of years took a pause and spent that time working for the Aboriginal Arts Board, part of the Australia Council for the Arts. She says in her book that she was inspired both by that work to see how Western intellectual property laws could benefit Indigenous artists, but also by aspects of the Mabo decision, to inspire her to go back and to complete her law studies, which she did when she graduated from the University of New South Wales in 1995. She worked for the National Indigenous Arts Advocacy Association, and in that position was involved in the Carpets case, something many of us in this room know quite well. And indeed, that case was led by Melbourne barrister Colin Golvan, who is very disappointed that he's not able to be physically in the room with us tonight due to ill health, but we know he's watching online, and I acknowledge, as I'm sure Terry does, Colin's involvement in that significant case. In 1998, Terry contributed to the Our Culture, Our Future report on Australian Indigenous cultural and intellectual property rights. Again, a report that we know well, setting the foundations for a slow but inevitable process that we're exploring tonight. She's been an expert consultant to WIPO on traditional knowledge and traditional cultural expressions in the Pacific region. And yet, so perhaps very impressively to me, she's not just involved in policy and thinking, but she's involved in the practice of law. In 2000, she set up her own law firm. When I looked on the website the other day, there were 24 smiling faces. This is not a small law firm that she's been running. And indeed, it has claims to being the largest and oldest Indigenous law firm in Australia. And if that's not enough, she's continued her academic pursuit of this topic, undertaking a PhD at the Australian National University, which she completed in 2019, and that thesis formed the basis of her 2021 book, True Tracks, Respecting Indigenous Knowledge and Culture. So you can see why we have Terry to speak to us tonight. And all I want to do now is ask you to join with me to very warmly welcome to the lectern to deliver the 16th Francis Gurry Lecture on Intellectual Property on the topic, Tracking for Change, a Pathway for a Future Indigenous Cultural and Intellectual Property Law, Dr. Terry Janke.
Thank you very much for your introduction. It's really great to be here tonight. I'd like to open by paying my respects to the Aboriginal traditional owners of the land we're on today. I pay respects to country first and the ancestors who nurtured this country, the land and the waters, to the Wurundjeri Woiwurrung and the Bunurong people of University Melbourne, where we are today. Whenever I give an acknowledgement to country, I feel this profound sense of connection to the land that I'm on, and that gives me connection and reminds me that we are on land that has an ancient legacy. A legacy of storytelling, innovation and resilience. And First Nations people are the custodians of the oldest living cultures of the world. And it is their knowledge systems that underpin the very topic I'm going to talk about today, Indigenous cultural and intellectual property. I'd like to formally acknowledge the Dean and also Andrew for having me speak today, and acknowledge First Nations people in the room today for coming along for this topic. I'm going to discuss Indigenous cultural and intellectual property protection and how it's essential. When I heard Andrew talk about all the years I've been working on this and all of that, I thought like, oh, how am I going to get this down to 30 minutes and keep everyone engaged when I've got so much to say? And it's quite a complex topic. But I'm going to talk to you about the work that we do in the firm, basically. I have a law firm, as Andrew said, it's on Bidjigal country, and we empower First Nations people in their arts, culture and business, and Indigenous cultural and intellectual property is a large way that we do this. I want to make the points today around what is Indigenous cultural and intellectual property, talk a little bit about Australia's legal landscape, and then go through the protocols, the True Tracks protocols that I developed in response to the gaps in the law, and then talk about a pathway to ICIP legislation. But before I do, I wanted to say some words in honour of Francis Gurry. In 2029, when the lecture was set up, Francis Gurry was the first to deliver the lecture series. And he is a distinguished leader, and as the former head of the World Intellectual Property Organisation, he played a significant role in advancing IP. And his vision laid foundation for this lecture and continues to inspire dialogue. He was the Director General when I travelled to WIPO several times to speak at the WIPO Intergovernmental Committee. But tonight I'm going to talk about Indigenous cultural and intellectual property and the misappropriation of art, culture and cultural expression and knowledge as a global issue, which it has been for decades. And if we think about intellectual property, we think of the Berne Convention, the Paris Convention, very old conventions in 1883, 1886. But when those key documents were being put together, First Nations people weren't there. We were still struggling for our recognition and a survival for our very lives. But in the past 50 years, Indigenous people have called for greater recognition of intellectual property. And this is why WIPO established the Intergovernmental Committee. And it's been going for 24 years. And they've been examining how IP laws can be used to recognise Indigenous knowledge. And this year there was a significant milestone with the adoption of the WIPO Treaty on Intellectual Property, Genetic Resources and Associated Traditional Knowledge. And it was the first of its kind to recognise the rights of Indigenous people over genetic resources and traditional knowledge. But at its core, this treaty is about patent disclosure requirement. And its mandate is to require applicants seeking patents to disclose the origin of the genetic resources by way of their country and whether or not there was traditional knowledge at its source. And it's an important step towards transparency, ensuring contributions of Indigenous people are acknowledged. But what does it mean for Indigenous people? The disclosure requirement is a mechanism to track change. It allows Indigenous people the chance to challenge novelty, an inventive step, if it's based on traditional knowledge. But it could also enable contributions that are collaborative and equitable sharing of benefits. Now in Australia, we have access and benefit sharing arrangements that could also enable better sharing. But where are we now? The treaty is not yet ratified. We need 15 members to do that. And Australia has signalled that it may sign that. And if it does, there'll be stronger ICIP laws. The question is how patent officers will implement it and then move on to how the wider rights of Indigenous people will fall into place. Because although the WIPO Treaty is a landmark achievement, it's just the beginning. We still have the two TCE, the Traditional Cultural Expression, and the Traditional Knowledge documents to be negotiated. And internationally, we have the UN Declaration of the Rights of Indigenous People. Article 31 is the assertion that Indigenous people have to rights of traditional knowledge and traditional cultural expression. And it's asserting the right to own, maintain, control, protect and develop this. And in Australia, we have a commitment from the Australian government to develop laws on Indigenous cultural and intellectual property. And it is moving towards 2 phases: protection of fake arts and also the wider knowledge. There has been consultations already, and a working group is being established to co-design the law. But firstly, I want to talk about why we should be protecting it. First Nations people have been storytellers for thousands of years. Their language, songs, dance, artwork, songlines are all their traditional knowledge. They have roles and responsibilities to it, and to assert rights to it is part of their cultural practice. So when I'm talking about Indigenous cultural and intellectual property, I'm talking about Indigenous people's rights to their heritage. And what is the issue there? Why do we need to protect it? Well, through many years, there has been misappropriation of knowledge, lack of recognition, occurring without consent and without benefit sharing. So this does 2 things. It demeans the cultural practices and distorts the meaning, thereby disconnecting Indigenous people from their culture and their dignity. And it also causes economic harm. It is unjust enrichment of the cultural pursuits of Indigenous people. So Indigenous cultural and intellectual property as a concept is very wide and holistic. In this diagram that I'm showing here, you can see that it is from land, it is communally owned, it is living culture in that Indigenous people are continuing to interact with it and nurture and development, and it is a core of their identity. You can see in this map that it includes things like artistic works, literary performing, ceremonies and stuff like that, but it also includes knowledge of plants, animals, cultural property and languages. It's a very wide set of things. Industry and government are increasingly seeking Indigenous arts and knowledge in areas such as art, design, fashion, climate change management, food security, education, science and technology. However, what we are seeing is widespread misuse of Indigenous stories, designs, arts, knowledge without consent. Hence the call for protection. Indigenous people are calling for rights to require free, prior informed consent, to be recognised as the primary guardians and interpreters, to benefit commercially, to prevent derogatory use and to maintain secrecy. But how can they do that now within Australia's legal landscape? It's always scary to want to talk about law in front of a room full of copyright or IP lawyers, but I'm going to have a go to look at the gaps in the law. Copyright law has been a main area of legal interaction with cases like Milperu and Indofern and the Bullen case, highlighting the complexities. But you can see here the gaps in the law. Copyright laws focus on expression and material form, where ICIP and knowledge, it's the style or the underlying theme that's really important, and it may be orally and performance-based rather than written down. Copyright laws are about individual rights. ICIP is about communal rights. Copyright brings economic rights, but cultural rights underpin ICIP. Copyright can be assigned. Cultural rights will want to be contained and kept within communities. And there is the public domain issue. There's a limited protection of IP. But when we talk about cultural rights, they keep continuing. But we have had a lot of discussion in copyright law, the Milperu and Indofern case, for example. Thank you very much. where we saw the award of cultural harm damages. It was a recognition of the deep connection between Indigenous art and cultural identity. And in the Bullen and R&T textiles case, the court recognised the fiduciary duty of the artist. And this was a very interesting point. But despite these important rulings, copyright still remains an individual right and doesn't really recognise communal rights. Trademark law, another area of focus, particularly the use of Indigenous words and images. We've seen a trademark hearing, an opposition to do with the Borrowby case, the Blue Koala case, the trademark filed by the Commonwealth Games. And that raised very interesting questions about the rights of people to file a legal right to the ownership of the mark when it was not supported by all Yugambeh people. We've also seen Australian consumer law applied to Aboriginal art, and in the ACCC and Berube, the Federal Court ordered record damages of $2.3 million for breaches of the Australian consumer law for these falsely marketed products that were saying they were authentic and handmade, but they were made overseas, these sort of fake boomerangs and didgeridoos when they were manufactured in Indonesia. And in that judgment, the ACCC highlighted that it was a serious offence causing distress to First Nations people, and they emphasised that the award of the damages was for the importance of deterring this sort of activity. In Victoria, a very unique amendment to the cultural heritage laws has introduced protection of Aboriginal intangible heritage, and this is defined as knowledge or expressions of Aboriginal tradition, such as performing arts, stories, rituals, ecological knowledge. And traditional owners can register and have their heritage put on the Victorian Aboriginal Heritage Register. And once registered, any commercial use of that heritage requires permission of traditional owners. However, these provisions apply only to commercial use, and communities' uptake has been limited due to concerns of having a public register of where the government maintains this cultural knowledge. So now I want to talk about the challenges for lawmakers as we move towards these new laws. And I wanted to point to 4 key ones. I'm sure there's many that the drafters are looking at, but the key challenges that I want to raise today is around the scope of what should be protected, the individual versus communal aspects, because that will need to be about striking a balance. I think the consent processes will be very key, and also the cultural authority, who gets to say who can use culture. It was in Revive, the Australia's cultural policy, that the government said that it would prioritise and value Indigenous contributions in the arts, and as part of this approach, they outlined their intention to establish standalone or sui generis legislation. And this would protect First Nations knowledge and cultural expression, including the fake arts, the merchandise and souvenirs. And the policy went on to state that the law would be founded on 10 principles of respect, self-determination, consent and consultation, interpretation, cultural integrity, secrecy and privacy, attribution, benefit sharing, maintaining First Nations culture, recognitions and protections. Now, these are the 10 True Tracks principles that I developed as part of my legal practice, and Revive, as well as saying that the law would be based on these principles, also said that they would establish a First Nations board, which, among other things, had the role of promoting best practice protocols. And as I said, there would be these 2 phases, fake arts and then ICIP. The True Tracks protocols are a framework that I developed to deal with the gaps in the law of a very sort of Western legal system that looked on outcomes versus Aboriginal customary law system that was based on relationships. And at the heart of the protocol is respect. So you can see these 10 principles here as being a process or a way of thinking for people who are engaging with Indigenous knowledge to go through. So if we think about respect, it's about recognising Indigenous cultural and intellectual property as collective heritage. We move on to self-determination, involving Indigenous people in the decision-making. Consent and consultation requires us to think about permissions. And 4, interpretation is akin to moral rights to ensure that the stories are presented in a way that honours the context in the multiple versions. Cultural integrity is the same thing. We have secrecy and privacy, guarding sacred secret material. Attribution is acknowledging the source, and benefit sharing are the economic, non-economic benefits that First Nations people should receive for the commercialisation of their culture. And 9 is maintaining Indigenous cultures, looking for how they can guard and keep and nurture and protect towards the future. And recognition and protection is about systems like ISIP clauses in contracts, notices, labelling in contracts, what we can do to alert people of the need to follow these protocols. And what we've seen from bringing this framework into the work that we do is that they're setting up systems that can be, in some part, leading to best practices, but they can be enforceable if there's contracts associated with them. So we've applied True Tracks to the development of the Australia Council, now Create Australia protocols. CSIRO also has established protocols for the science research. Film Australia has pathways in protocols. And the Victorian Traditional Owner Native Food and Botanical Protocol is another one. But True Tracks can apply to situations from public art developments, bush foods and healing products, establishing database, libraries and collections, and what have you. And I think it is also a useful framework to look at in the development of laws. As I said, in the absence now, we are using IP laws, what we know of them, to vest where we can with First Nations people, and contracts can assist that with assigning or giving licences, but protocols also are part of the mix. So where are we moving to with this ISIP legislation? Well, the fake arts is a problem that's proliferated the souvenir markets. It's about artistic styles that come from regions in Australia that will be unique to First Nations communities, being copied from people overseas, mostly from overseas, but it can also be in Australia. The importation of these dodgy boomerangs and has been well documented. These copycat products sit alongside legitimate ones and cause harm to First Nations people. And it's estimated that 80% of the market is fake. So how do we deal with this problem? I mean, we know it undermines cultural integrity and misleads consumers, and it also takes away economic opportunities. So the problems are responses, as I've listed here. I'm thinking that the law should not require registration, but the rights should last in perpetuity and allow Indigenous people to act. So if we're looking at rip-offs of imported material, it could be controlled by importation or require certificates. Art styles copied by Indigenous people, not connected to cultural expression though, is a big issue. There have been consultations around Australia with First Nations people around how this fake art laws should be developed. And the very sensitive issue of First Nations artists imitating art styles that they have no belonging to, you know, cultural icons and stories from other countries has arisen. So this further complicates the question of authenticity. It's a question of cultural authority, and it will require different solutions than the copycats. So I'm looking here at the other problems with undermining cultural integrity and harm culture. We need communal moral rights, cultural harm damages, cultural protocols. With the Indigenous style arts and craft not made by Indigenous people, labelling and a trademark like the Indigenous Art Code and the former label of authenticity would be good things to look at. And unfair contracts is also listed as part of the problem. We need to consider how fair and equitable contracts can also be promoted. Then we'll see sort of rights that might be covered. So the list here, we can see the rights to stop, people taking it to market, importation of fake arts, false labelling, protection there of unfair contracts, integrity rights, sacred secret, attribution and cultural protocols. I think there are laws around the world that could also give us some scope to look into it. For example, the Indian Arts and Craft Act also protects traditional items of Native Americans, and it is illegal to label handicrafts that are produced by non-natives as native, and there would be a violation of the Act if someone who is not a citizen of those communities to do that. So these sort of things could be very useful. We also have things like the WIPO TCEs calling for the establishment of a competent authority for special protection, and most of these regimes emphasise community-based decision-making. Moving on to sanctions and remedies, it would be things like, stopping the activity, having fines, account of profits, damages for cultural harm, and being able to remove or destroy offending items, and having apologies or corrective statements. And I find that a very big sort of remedy that First Nations people want, as well as educating people about the importance of their culture. And it might also involve the removal of IP rights. There would also be, with respect to the second law, the Indigenous knowledge law, protection of Indigenous knowledge that's passed down through the generations. Knowledge such as songs, dance, stories and country, plant healing properties, cultural practices like weaving, oral stories and recorded knowledge. And this knowledge, being intrinsic to Indigenous identity, is about the cultural practice of speaking for that knowledge. And we have examples of exploitation in biotech industries. The example of the Kakadu plum and the smoke bush plants are there. So what rights would Indigenous people need to this knowledge? Well, it would be the right to consent before traditional knowledge is used commercially, and to share in the resulting benefits. So if the knowledge is associated with the genetic resource, that's where the WIPO treaty is relevant. But we would also need to think about those access and benefit sharing laws, and the need to ratify Nagoya Protocol would be important. The other thing is to look at fixation and recording and use of knowledge. So we know at the point of recording that creates IP, but it often doesn't belong to Indigenous people. So protection of recorded knowledge, such as language, histories, and all of that needs to be guarded. Collections as well, like things in archives, libraries, digital databases would also need to be looked at. And fair agreements, the transparent and equitable contracts and preventing exploitation there. We need to think about integrity and sacred protection and attribution of the cultural source. Examples of legal models are definitely there overseas, like Brazil and Panama have implemented the disclosure provision, which we're possibly looking at post the WIPO treaty. And there's also been countries that have developed a cultural authority. And these entities are collectives that have the powers to develop codes and ethics and standard terms and conditions of agreements and processes for prior and informed consent. For example, in the Pacific Model Law, which has been the basis of many of the Pacific countries' laws, has looked to develop a competent authority that will set these standards and enable the negotiation of the terms. So again, we would be looking at, in the use of knowledge, that Indigenous people would be able to stop uses that are inappropriate, particularly if they've never been made public. There would be fines and account of profit recovery, cultural damages, and again, apologies and corrective actions. A sticking point would be, how might this react to the revocation of patent rights or trademark rights, and it would be something that we need to consider. But what is a key thing in this mix is the cultural governance piece. These are rights for Indigenous people, and it may not be appropriate for federal courts or the systems that we know as today as IP lawyers to enforce accountability. We would need to examine that, and we will see shifts in the landscape. And this is where a national Indigenous cultural authority could be established. And this is important to answer the question on who has authority to consent to a communally owned piece of knowledge being used commercially. So there may be groups that overlap with that right. It is going to deal with individuals and collectives. The issue there remains, can the individual commercialise it, and what is its obligation to consult and work with the collective? So a National Indigenous Cultural Authority is not about making the decisions, because that needs to be done on the ground. The Indigenous owners of the knowledge will make that. But what it could be is a point of contact for users, because one of the common things that I come across when I'm working this area, and many people want to do the right thing, they don't know who to go to. If it's a big company, they want to use particular knowledge for a new medicine, who do we speak to? How do we identify traditional owners? Who do we get the sign-off from? How do we get the sign-off? Who do we pay? So those sort of things could be done by this National Indigenous Cultural Authority. It could identify rights holders, give a process where other people are allowed, other relevant stakeholders can also weigh in on their thoughts of whether the cultural asset should be commercialised. And it could set cultural protocols which guides people on appropriate use. And the standards of consent, which vary widely, could be formalised, and the complying agreement, which results in the negotiation, could be registered, and there could be monitoring. And we would also need to have dispute resolution, mediation, cultural leaders involved in deciding whether or not the uses are appropriate, and basically going through those 10 principles. So that's a lot to think about, I know, but you can see here the forming of a landscape that may be different from what we know, but would be more fitting to dealing with Indigenous knowledge. But I want to also say a bit about additional challenges, because as we are doing all of this work to define and establish the laws, we are also being met with new challenges. And the challenge of artificial intelligence is a big one. And AI has grown in the last few years to amplify these risks of Indigenous cultural and intellectual property misuse. And where Indigenous knowledge and Indigenous people want this connection and consent regime, and to speak for culture that comes from their place, AI can take that even further out of the control of First Nations people. We can see data fed into systems where the AI may scrape off the internet various data sets, traditional knowledge about country, biodiversity, language and much more, and the AI won't be able to follow those protocols unless we have some very good software designers and new platforms, which could be a challenge. But what we're seeing now is the results of AI trying to call up Indigenous cultural knowledge, and it's a mix of cultures. it's potentially offensive to First Nations groups, and it provides wrong information. So AI will have to be dealt with in how will AI protect culture. We've also got to look at the issue of having resources for implementation. No good in having the laws without that, because as I've looked at other laws, they look very good, but the implementation has been low. And information systems, how we manage them will be very key. Inventories of what is collected and how we tag what we do collect in the future will also be important. So going back to the True Tracks principles, as we move forward, it's really important to observe how governments will approach the implementation of these laws. And it'll be a challenge for us, particularly us as IP lawyers. How is it going to fit with our system? But we have to embrace these approaches, these True Tracks principles, to empower Indigenous decision making. And we'll move towards collective and Indigenous-led solutions. So the True Tracks framework is what I offer for that, for you all to think about. I really think it's an important time in the history of looking at these issues, and we can create a system that not only protects cultures, because First Nations people are also looking to innovate and build partnerships and prosperity, but it is also with collaborations that are built on respect, care, and the vision to work together in the spirit of collaboration that we will share in the prosperity that traditional knowledge can bring to Australian innovation. Thank you very much.
Well, thank you, Terry. Actually, it's our great pleasure to have heard all that. And it's actually the very first question that's come in. It's quite relevant to this particular building. From Anonymous says, it's pretty clear that an understanding of culture and what intellectual property is will be incredibly important in the future. Should universities be integrating some basic training of this into all its degrees? Or should you, perhaps I can just say, what role do you see for universities here in assisting in facing and addressing the challenges you've outlined?
Definitely, I think universities should be teaching Indigenous cultural and intellectual property. It's such a wide-ranging topic. And when I went to law school, I studied intellectual property, but I didn't know what it was when I first started. It took me having to leave, as Andrew said, I left and going to work in the Aboriginal Arts Board to know its importance to First Nations people, dispossessed of lands, but knowledge being so important to the cultural, their cultural strength. And we need to obviously also encourage more First Nations people to study intellectual property.
Absolutely, I agree. Again, another one, not the same, Anonymous, I assume, but it's Anonymous. Sort of a legal structural issue here. Australia is a federation capable of recognising multiple legal systems, so it does in a federation in the Western law sense. What would be a good way to protect Indigenous traditional knowledge, traditional cultural expressions, using Indigenous law? So I'm going to put the question this way. Do you see a role for Indigenous law here to be used as distinct from a modification to Western law?
Yes, and that's why I feel the framework with True Tracks has been very flexible to enable First Nations people to control and make decisions around how it's used. I think, though, what's needed is where there are disputes, and sometimes it doesn't work, we need to have a system where there can be some sort of arbiter or authority that people can take to. So I do think that those decisions are still made, but the question is on enforcement. those measures of enforcing through customary law may not be appropriate. Like taking away the rights to paint as a penalty for transgressions, or spearing someone in the leg or something like that is not what we do in Australia in the modern day. So we've got to think about how we can prop up that system. So the National Indigenous Cultural Authority could do that, but it is obviously something that groups could look to call to. In my workspace, we actually do get a lot of calls from First Nations people who are saying that particular use of our knowledge is not by someone we know. Someone not Indigenous to our group is using it. And so although they want to, within their group, deal with it customarily, they have no legal recourse. So it's a challenge. Do we allow avenues to the federal court? And maybe we do. We have seen that in native title, for example, systems like that. Heritage decisions, so it could be an extension of that. But I really see, again, the ability of the laws to open up. And we've seen it in those cases I mentioned, recognition of IP laws, bringing in aspects of customary law. And I think we're going to see more of that as we move to protect this.
Okay, thank you. Just a follow-up, a question I think connects to a degree here with what you've just said. It's about, it starts off saying, how can new laws and processes be made accessible? Red tape can be incredibly inaccessible. And as I was listening to you and the various challenges you rightly identify, I started to feel a little bit overwhelmed actually by the task. And perhaps this is a question I'd like to ask you, is the government has said it's looking at standalone legislation. I'd be interested to hear your views about whether or not you think the aspiration of standalone legislation to deal with that multitude of challenges is the preferred model, or whether it's continual expansion of existing laws in the way that you've already shown has happened to a degree.
Well, I'm in favour of standalone, sui generis, and I also think that will change the existing laws. It will be a challenge. I mean, this is very complex, and we're getting little wins through, as I piece through with copyright, trademarks law and consumer law. But the sui generis law really is the fundamental recognition of Article 31 of the Declaration of the Rights of Indigenous and People and their rights. I think it is the vehicle that will enable greater Indigenous decision making, and that nexus of bringing the two together, that the sui generis law could be. It is a challenge. I mean, back in the 80s, there was a model for protection of Aboriginal folklore. We're at it again, but there are countries in the world that have models like this, so it can be done. The standalone legislation it'll be interesting to see how prescriptive it is, because the government has said fake arts and then ISIP. I probably would like to see it all together because they're so interconnected, but it's responding to the proliferation of the fake arts in the first instance, and the Productivity Commission's report. But the sui generis is really the purpose-built system that First Nations people want and have been calling for. So I'm in favour of that.
Mm-hmm. Okay, thank you. This question, I think, touches upon something you've said then and also in your presentation. It's a simple question, not necessarily easy to answer. Is there a country you think embodies best practice for ISIP protection?
I think there's elements of many countries that have looked at legislating this. Like if you look at models in Brazil or Panama, in South America, they've set up competent authorities, much bigger Indigenous populations than Australia, and the complexity of all the different Aboriginal and Torres Strait Islander groups may not be so prominent, although I can't say for sure that they haven't dealt with that complexity. I think African countries, and I really like the Pacific model law as well. We've seen areas of Southeast Asia develop models as well around biodiversity and protection there. I do like the Indian Arts and Craft Act around those dealing with the fake arts. So there's a lot to gain from everywhere, but we will need to consult and get a model that fits Australia. And we have the World Intellectual Property Organisation speeding up to, well, hopefully speeding up. It did take 24 years for the recent WIPO treaty, but they're going to look at TCE and TK. So hopefully that can give us a model. But we're uniquely going to, if it does go ahead, Australia will develop a model before all of that occurs. So perhaps when you ask me that question in another few years, I'll be able to say Australia.
Wouldn't it be good to hear that answer from that question? Thank you. Question from Olivia Kelly. While we wait for more appropriate frameworks to protect knowledge and property of Indigenous people, so in the meantime, before we get to the point where you can say Australia now is the model country, do you have recommendations for how we can adapt our current practices to better support these communities?
Thank you, Olivia. That's a good question. I think it is through the True Tracks protocols, following those 10 principles and challenging the way you do things. I have a firm, we have 24 people that are working for people on this, First Nations people and those who want to respect culture. We act for Aboriginal organisations, Aboriginal language centres, art centres, and we act for governments or businesses that want to use Indigenous art or knowledge. So I would say challenge the way that you might approach the transaction. For example, it might be the thing for an IP lawyer who's negotiating with an Indigenous artist about the use of their work, in a project, if it's fashion or public art or building design. It might be something that their approach might be to either seek an assignment of the IP or to negotiate a very wide licence. I would say what you could do is take a negotiated approach. You don't need all the rights. Talk to the Indigenous artist or the Indigenous knowledge holder about what you need to do. Is it like a non-commercial right that you only need, limited for a number of years? Can you tell them the different purposes and reproductions that you're going to use? Because there's a big difference in allowing it to go on the cover of a rap report, or if it's negotiated on a carpet, for example, and you can put works on carpets if it's appropriate to, then allowing it to be put in a database and scraped by AI. So what I see my clients liking is to be able to negotiate those rights so that they have something to hold on to. So that's an easy approach for IP lawyers to take on. And really think about those contracts that you're drafting, that you don't want to take away these rights. How can you give life to integrity, that right of integrity and keeping it true? And that already would be amazing, because a lot of my First Nations clients are struggling with trying to get companies to understand, and even if they do get the companies, the person that they're dealing with, the next hurdle is to get the lawyers who are writing the contract to understand. So, just think a bit wider on how you draft those agreements.
Well, that leads into a question that came up earlier, but I now think is appropriate to ask. And I think I know why. It's from Anonymous. We have clients interested in including ICIP clauses in contracts, so doing what you're suggesting. How do you feel about lawyers adapting clauses you've drafted?
Oh my goodness. Well, don't adapt them and make them oppressive, because I've seen that done before. Yeah, I guess we've done a lot of the drafting in agreements, and you may see them in there. I think it's, I don't know, is it my intellectual property? But it's something, I guess, in the long term, if it's used to support a change in the way we do things, it's possible. And I know there's a lot of agreement clauses that I've done out there in the public, but I would also say, if you're going to use the clause, use the notices and really commit to best practice. If you're doing them for clients, use the clauses with integrity.
Yep, good advice. This question, there appears to be a tension between, it's setting up a dichotomy between Western IP rights that have limited duration copyright patents on the one hand, and the perpetual nature of certain cultural rights or aspirations. How do you think that dichotomy, that tension as the questioner calls it, can be reconciled, if at all?
Sorry, is it the dichotomy between?
Between the fact that Western legal systems with respect to IP rights typically, not always typically, have limited duration, the rights are of limited duration, and yet, as you would recognise, and we understood from what you were saying and the questioner recognises, aspirations for protection, particularly showing respect, etc., is, I assume, meant to be continued in perpetuity. Do you see there being a tension there?
It can be, and it does come up in our work because I guess with copyright, or let's say copyright, there's an end point where you don't have to get permissions anymore, and theoretically you can also alter the work. But with Indigenous cultural expression, you wouldn't be able to do that. So old rock art would still need those respectful protocols that you need to follow. I don't think it's, I think it can be a tension when people can't find who the people are. So, I mean, I guess that's a problem even with 70 years. We have orphan works. We've got to keep really good records, haven't we, if we're going to have this, which I think we can do. And there's got to be inventory or going through old collections of photographs and what have you to work out what that knowledge is. And that can be a big tension because do you lock it up? If you can't find who the person is that created it, or you can't go to a group to get information, say it's a film or a language recording, does that mean you can't use it anymore? And it could be a problem. So I think we need to have a model that deals with that. I think the cultural authority could deal with it. You've got to go back to principles about having respectful use. So if you can't get consent always from those people, have you got alternatives to check that your use is culturally appropriate and respectful, and to think about the context that you're going to reuse it. And in that way, I guess you might not have to get consent from the person. I still think, best practice would be to do that. But you've also got to think about if it's something that's, widely known or publicly available, how you can keep that context very, very respectful.
Okay, and this question connects, and maybe you've effectively answered, or maybe not, but I'll put it. It sounds as if moral rights have a very significant role to play before a substantive standalone ICIP law comes into effect. Do you agree?
I think we do need recognition of moral rights. We're talking of moral rights here being the right of integrity, which links into, I guess, in the true tracks, interpretation, cultural integrity, and perhaps the secrecy, privacy part of it. It would be useful. But that's just recognising the connection. It's not giving people rights. So you need to have the economic rights as well. Not that I don't think it's all about commercialisation, but if there is economic opportunity to be made, and I think there is, in new medicines, you know, fashion and art, and the application of cultural practices to climate solutions. You know, there's a whole lot of ways that Indigenous knowledge can be used, as it has in the past. I would be looking for the economic part of it, because there has been this, I guess it's a hangover from cultural heritage and a preservationist approach to Indigenous rights in this area. It's like, Indigenous people are the ethnographic value, aren't they? Wonderful, primitive people. And we need to protect and preserve their culture. And don't recognise that we also want to use it and innovate and build economic prosperity from it. So that preservationist approach needs to also be alongside an economic approach and an innovation approach for First Nations people to be involved in it. Because right now we have First Nations communities that want to utilise their land and resources for new medicines. They want to work with tech companies. You know, you have artists that want to develop, you know, fashion items and what have you, but they just want to make sure that they understand the risks and that the people that they're in business with can really connect with the cultural values and not just think, oh, great, we got the go-ahead and now it's going to be adapted so it's out of context and no longer culturally respectful, or it's just so mass-produced and just taken away from that connection that First Nations people want. So I think that we need to really look at that economic right. Indigenous people have an economic right.
Entitlement, absolutely. And this, I'm going to take the privilege of this, making this comment before we wrap up, because it's not a question. It's from Shelley Cable. She says, not a question, just a comment to say thank you, Terry, for sharing your knowledge and just some of your inspiring work through this lecture, but also for your ongoing leadership and advocacy over many decades. I wish you all the success in bringing your recommendations to life. If you win, we all win. Well, I hope Shelley's comment hasn't taken the thunder from Dr. Grant Shoebridge, who I now call upon to bring tonight's proceedings to a formal close. Thanks, Grant.
Thank you, Shelley.
Thanks, Andrew. I just want to say, look, it's always a great privilege to be part of the Francis Gurry Lecture. And I think you'll all agree that tonight's presentation has been a thought-provoking and energising one. There's no doubt from tonight that the culture of Indigenous Australia, the incredible art and the powerful storytelling, it really needs to be valued and not only protected, but also nurtured. And really, I think that if that doesn't happen, Australia is going to be a much poorer country. So it gives me great pleasure to be able to say thank you, Dr. Janke, thank you, Terry, for your outstanding, not only your outstanding contribution tonight, but your outstanding work in this field widely. I want to also reiterate thanks to the sponsors of the Francis Gurry Lecture. They don't have a banner up tonight, but I think AIPPI, IPSANS, IP Australia, and I certainly want to recognise the work of IP Australia in this field as well. They're doing a lot of work. And also Lausanne's. I'll also recognise the founders of the Francis Gurry Lecture, of course, the University of Melbourne, and my outfit, the Institute of Patent and Trademark Attorneys. Finally, I just quickly want to say thank you to everyone in the audience, both here and online. As Andrew said at the start, we greatly appreciate your time and your engagement. And it really goes a long way to making this a significant event. So thanks very much, everyone, and have a great evening.